How do I modify a child support order? How do I change my child support order? After a judge makes a child support order, one of the parents or the local Department of Child Support Services may want to change the order. In this video, you learn how to request a change to your child support order and what forms you will need if you have reached an agreement, referred to as a stipulation, on a child support amount. Change in circumstances. As a general rule, change in circumstances must be shown before a child support order may be modified either to a higher or lower amount. However, if the parties entered into a written agreement, stipulation, which was signed by the judge, to an amount below the calculation set by the state guideline, you do not need to demonstrate a change in circumstance. What are some examples of a change in circumstances? Significant change in one or both parents' income, loss of a job or reduced hours, a promotion, increase in pay, incarceration, change in custody order, change in the amount of time the child or children spend with each parent, change in the child's needs, for example, childcare, healthcare, education. After a change in circumstances occurs, does my child support payment automatically change? No. The child support order can only be changed by a new order or an agreement, stipulation, approved by the court. How do I request a change in child support? File court forms. In order to request a change in child support, you can seek assistance from the Orange County Department of Child Support Services or file a request for a hearing with the court. You can reach the Orange County Department of Child Support Services at 1-866-901-3212 or online at the following link. The Orange County Department of Child Support Services is located at 1055 North Main Street, Santa Ana, California 92701. Cashiers are now accepting in-person payments in their customer service lobby from 7 a.m. to 4:30 p.m. If you would like to request a hearing with the court, you will have to file a request for order for child support and supporting documents. The Self-Help Center has compiled the necessary forms in a packet. You can access the form packet by following this link. With your request for order, you will have to provide the judge with a statement, referred to as a declaration, to inform the judge as to your reasons for asking for child support. In your declaration, you can attach any proof, referred to as evidence, to help support your statement. With your income and expense declaration, you will be required to provide information regarding your income and household expenses. You will also have to provide your pay stubs for the last 2 months. California has a statewide formula, referred to as the guideline calculator, for figuring out how much child support should be ordered. Also, if both parents and the local child support agency, if involved, agree on a new child support amount, all parties can sign and file a stipulation to establish or modify child support in order, Form FL-350, or Stipulation and Order, Governmental Form FL-625, for judicial approval. If parents cannot agree on an amount for child support, the judge will decide the child support amount based on the guideline calculation. Service. After you file your forms, you must have the other parent served and the local child support agency served if they're involved. Someone over 18 years old who is not a party to the case serves a copy of your filed court forms at least 16 court days before the hearing. Add 5 calendar days if service is by mail. The server also serves blank copies of the responsive declaration, Form FL-320, and Income and Expense Declaration, Form FL-150, and fills out the proof of service. You must then file the completed proof of service with the court. Attend your hearing. Be sure to attend your hearing and be prepared to explain the change in circumstance that occurred in your case. You should also be prepared to present any documentation that helps support your request. In addition, be sure to take a copy of your tax returns for the last 2 years and last 2 months of pay stubs. Should I wait to file for a change in child support? It is important that you seek a modification right away because child support cannot be changed retroactively. This means that if you lost your job 3 months ago but are just now filing papers to change your support order, the court is not allowed to make an order going back to the day that you lost your job. The court can only change your child support from the date that you filed your papers asking for the change. If you wait, you will not only be unemployed, but you will owe 3 months of child support, plus interest on the past due amount. As a result, it is important that you file as soon as possible. Please note, as a response to the COVID-19 pandemic, the Judicial Council of California enacted Emergency Rule 13, which will temporarily allow a court to make an order modifying support effective the date an unfiled request to modify support was mailed or otherwise served on the other party, so long as the requesting party also reserves the other party after the request has been filed with the court. What the emergency rule allows you to do is complete the following packet: SHC-RFO-01. Once completed, you must have someone else over 18 years old serve a copy to the other parent by mail. The person that mails out the copy, your server, needs to complete the proof of service by mail, Form FL-335. The other parent also needs to be served with a blank responsive declaration, Form FL-320, a blank income and expense declaration, Form FL-150, and a blank proof of service by mail, Form FL-335. All these forms can be found in this packet, SHC-RFO-01. Please note that if the Orange County Department of Child Support Services is involved in your case, you will also need to have someone else mail them a copy of your unfiled forms. The person that mails out the copy, your server, needs to complete the proof of service by mail, Form FL-335. You must file your original completed packet with copies, along with the proof of service demonstrating that you had them served with your unfiled request. The court clerk will file your original and give you back the copies with your hearing date. Then, you must have someone else reserve the other parent with a copy of the filed paperwork. If the Orange County Department of Child Support Services is involved in your case, you will also need to have the department reserved. You must have them served at least 16 court days before the hearing. Court days are days that the court is open to the public. If the documents were delivered by mail, add 5 calendar days to that deadline. Now you know how to modify a child support order.